intellectual property section, and I have partner and chair of the corporate group, Andrew Fine, with me today. And we're going to be talking about building and protecting your hospitality brand. And just, a couple reasons that this is important is that, you're putting so much time into building your brand, training your staff, really putting everything into developing your brand. And guess what? If you do not do it properly, you could lose it all with one cease and desist letter, or if you set up your corporate structure incorrectly, it could all fall for pieces, and all of your hard work could really just tumble in a blink of an eye. So it's really crucial that you guys pay attention today, ask questions, because we're here to help you protect what you've built. Another thing that's really important, and if you take nothing else away from today, I want you guys to really, sear this into your mind. Your brand is your most valuable asset. I'm going to say that again. Your brand is your most valuable asset. It's more than your build out. It's more than your inventory. It is truly what's going to help you scale and monetize your concept. So it's really important that you protect it. And one last thing is that, a lot of you are coming to us in the beginning of your brand development process, and you're working with a lot of concept developers. And guess what? And marketing people, they're not going to talk about intellectual property. They're not going to talk about your corporate structure. So it's really important that you guys pay attention and really take some notes so that you can look out for yourself, because it's really important. Not, a lot of these design professionals, and you can't blame them, right? They're not lawyers. They don't know what to look out for. And so it's really important that you guys are paying attention to asking these questions. So we're going to dive right in. We're going to start with some kind of, some trademark basics, and then we're going to go into some corporate structures, and then we're going to end with some monetization strategies. So Andrew, why don't you talk to us about this beautiful legal disclaimer?
Sure. I'll make this quick. Just as a quick heads up for everybody, this is not legal advice. We're doing this for information purposes only. Like I said, we're going to be speaking in very broad generalities today. The specific facts and circumstances of each of your cases may be different. So if you have specific questions, please reach out to us separately. This is, like I said, this webinar is really just for information purposes only. This is not to be construed as legal advice. And that's that. Moving on to the fun stuff.
Great. All right. So, and as Andrew had mentioned, if you guys have questions along the way, pop them in the chat. We'll do our best to answer them as we go. And also there will be some time at the end for some questions. So what is a trademark? Does anybody know what a trademark is? I wish I could be in a room right now, but I'll give you the answer. So a trademark is a source identifier, right? You're looking here and you're seeing all these different trademarks. They are a source identifiers to let the consumer know who provided the product or the service and what type of quality they can expect. Move on to the next slide. So what are the benefits of a trademark? We get this question all the time. First of all, it allows you to establish and maintain a brand identity. And the reason that you want a brand identity is that you want to be able to give consumers a reason to come to you, right? Your brand identity is what differentiates you from the Mexican restaurant across the street. It really allows you to pour your marketing efforts and your quality and everything into an identity that you can then capture and monetize. It also allows you to protect the goodwill and the reputation of your company. Again, you're working so hard in training your staff, in putting together procedures, and curating that menu, and developing that amazing customer service. You want consumers to be able to attach that to your brand identity. And you do that through a trademark. There's also benefits of territorial protection over competitors, right? If you come up with a brand identity and a name, you want to make sure that you've kind of staked your claim over that and that somebody else can't just steal it and run off with it. And of course, there's advantages in court, which we'll get to later. So for all of those reasons, it's really important that you invest in a trademark. what do the symbols mean? We get these questions a lot as well. So the R with the circle means a federally registered trademark. That's the only meaning for an R with a circle. You cannot use this symbol unless you have a federal registered trademark. TM can mean several things. It can mean a state registered trademark. It can mean a pending federal application. It also means common law rights, which are rights that you get by virtue of just using your mark in commerce. Same thing with SM, that technically means a service mark. Trademark is technically reserved for products, but they are used synonymously. And once again, it means the same thing. It could mean several different options: pending federal application, a state service mark registration, or common law rights. So just be careful when you're using these things, but understand that they all have separate meanings. All right, what can you trademark? You can trademark the name of your restaurant or your business name. You can trademark your logo. You can even trademark some distinct items on your menu. Let's say you've got a crowd favorite and you've got a really unique name. You can absolutely trademark those things. What can you not trademark? You cannot trademark a picture or a website, a cookbook, or a recipe. All of those things are reserved largely by copyright, although a recipe is not protected under copyrights, so or trademark. So things to keep in mind. Oftentimes people confuse what a trademark is, and it really is reserved for names, taglines, and logos. Sometimes you can trademark a chef's name or a family name if it has achieved some level of famous statue, like kind of you see here by Jose Andres. And we've got the Bazaar, right? That's a trademark, but he also has his name Jose Andres trademarked as well. And that's developed after years of use and consumer identification. Sometimes you can trademark a color. Again, it's very difficult, but it's happened before. And sometimes you can trademark trade dress, which is the way that a product or a restaurant looks. And we'll get more into what that is. But generally, this is what we're speaking. So trade dress is, again, the unique characteristics or the visual appearance of a product when we're talking about it. So of course, think about the Coca-Cola bottle or the Casa Azul bottle. These are distinct bottles that if you look at them, you immediately understand. Even if you didn't have this Coca-Cola symbol on it, you would know what it was. In the context of a restaurant, a trade dress is the unique appearance of a restaurant. That can include uniforms like you have here. That can include the way that your benches or seating arrangements are. If there's some kind of kitschy or classy signature unique appearance to the way that your restaurant is being operated, you might be able to trademark it under a trade dress application. All right, Andrew, tell us.
Sure. So this slide is called Who Owns the Trademark? And the reason we called this slide what we did is this is probably one of the most overlooked questions in the formation of a company, period. We often work with clients that have either use different lawyers or legal Zoom documents or ChatGPT to create early partnership agreements. I can't blame people for doing that. It happens all the time. We get it. Money is tight. You want to move quickly on something, but it's very rare that you see one of those documents actually describe and contemplate the ownership of the brand at the front end. Not thinking about brand ownership at the beginning can be very, very expensive. And it's only likely to be an issue, ironically, if your brand is successful, right? Nobody's going to fight over the ownership of an unsuccessful brand.
But I always say the haters come out when you're on top.
Exactly. And that's kind of the name of the game when it comes to brand protection. If your brand performs as you hope it will, everyone's going to want to get in on that success. Nobody's going to ask who co-owns the IP and in what proportions at the beginning. Nobody's going to ask that. That question's going to come up when your first concept is a blowout success and you want to open a second one. That's when the questions and the disputes are going to arise. We get this question all the time. I have a restaurant. We have some investors. We want to open a second one. What can we do? Our response, Hamutal and I, is always the same. My response is, let me take a look at your partnership agreement, your operating agreement, your shareholders agreement, the contract that you signed with your partners from the beginning. If you don't have one, we're out of luck, because the default is, well, the company owns that asset, and everyone attached to that company, anybody who owns interest in that company, has to participate in some way in that future expansion. Right? What does that mean? That means maybe the second location pays the first one some kind of licensing fee for permission to use it. Maybe it means you give some equity to the original owners in the second one, but it can become very murky. So understanding who owns the brand, and when I say trademark, I'm including a lot of things in that, right? Who owns the brand as a whole, the trade dress, the logo, the IP, the look and feel, to the extent you have proprietary recipes or trade secrets, all of that gets bundled into what is commonly referred to as intellectual property. So you'll hear us use the term IP, which is the abbreviation for intellectual property. That's what we're talking about today, is the importance of understanding how to structure that and how to make sure we make it clear to you and your partners who owns it. So the question of who owns the trademark or who owns the IP really comes down to, what agreement did you make on the front end, right, before you opened? It can be owned by your company, it can be owned by a series of individuals, it could be owned by one individual, right? Ideally, we could go to the next slide, Alex. You're going to create a company to hold this asset. As Hamutal said at the beginning, your brand is probably your most valuable asset. The bigger you get, the more valuable this will become, right? If you have one location, maybe the brand isn't as valuable as, it would, your FF&E, but the more you grow and the more you use this in commerce, the more that the value of your brand will start to eclipse everything else by huge degrees. So understanding that this is an asset that you want to protect informs the idea that you want to create a separate company to hold your trademark and, by extension, all related intellectual property. The reason you want to form a separate company in most cases for it is to just give that extra layer of limited liability protection, protect it as best you can. And again, just make sure that you're insulating that as much as possible.
Well, and for example, let's say, and this is me putting my litigator hat on, let's say somebody slips and falls in your restaurant, right? And then they sue the restaurant. Or let's say that, God forbid, they eat a shoelace in your pasta and they sue the restaurant, and your operating entity owns your IP. Well, now that asset, your IP, your brand, your trademark, is now susceptible to any sort of litigation, right? To any sort of judgment by a court. However, if you listen to what Andrew is saying right now, you can insulate that from ever happening, because in the case where your IP assets are held by your IP holdco, that's why we call it a holdco, it's a holding company. It truly only owns your IP, that's it. It doesn't enter into any vendor contracts. It doesn't really expose itself to any sort of liability. Then in the case of you get into a lawsuit again with a unhappy customer, with your landlord, anybody else, your IP assets are insulated. They are off to the side. They are absolutely not involved in any sort of litigation, and that just gives you just again another layer to insulate. Sorry,
Yep. No, it's great, because it really does illustrate why we do this. It's to protect it from the unknown, and it's to protect it from, your worst case scenario. It also, on a more positive note, creates a launching pad for you to enter into license or franchise deals, which is basically other ways to monetize your brand. The bigger your brand gets, the more successful it becomes, the more opportunities you have to actually profit off of it, right? So creating an IP holdco gives you a platform through which to do that. Depending on how you're structured, if you don't have an IP holdco yet, it's possible to form one down the line. We have a lot of clients that say, look, this might be the next big thing. This might be the next Chipotle. It might not. Let's wait and see how it goes. That's possible as long as you still contemplate IP ownership in your initial contract with your partners.
Yep.
You have some clients that do it right from the get-go and say, look, I'm going for broke. This is either going to grow and expand, or it's going to close, and we form an IP holdco from the get-go. Some clients choose to do it down the road. Either way, it's a good thing to do if you're really starting to invest in growth and you see the brand as something that can really expand.
Yeah, and I mean, we're talking about, really something inexpensive. Same thing with filing trademark, very inexpensive. These are things that are, not complicated, inexpensive, and we can help you with. So really, you can't really do this too early.
Right. Setting up the IP holdco is the easy part. The tricky part becomes answering the question, who owns the brand, right? And what are the different kind of permutations of that ownership? Alex, we can go to the next slide. I think that's a good transition. My biggest my biggest takeaway, if you have one takeaway from my bit as part of this webinar, is make sure you set expectations for your brand at the beginning. It's so easy to forget about talking about IP ownership when you're first starting out, but it is so important. It only become more important as you grow. Because basically the ownership of your IP, your intellectual property, dictates who's entitled to participate in the expansion of your brand. If you open a restaurant, you fail to specify who owns the brand, your partners, your investors, anybody, doesn't matter whether they own 99% of your restaurant or 0.01% of your restaurant, they will all expect that they co-own the brand with you. That means if you open a second one, you got to account to them in some way. What does that look like? Like we said, could mean a licensing fee, could mean you have to dilute yourself in the second one to give equity away. It can take different forms, but the general premise is, from the investor seat or the partner seat, hey, I helped you build the first one. You wouldn't have an opportunity to build a second one, but for my contributions, you told me, or it was implied I was getting onto the ground floor of something that could grow. You got to account for me now. We've seen many lawsuits over this. Many lawsuits.
The word implication just makes me want to cringe. You never want to leave we don't want gray. We want black and white. We want it specifically laid out. And really, I mean, you can decide what you want. We've got chefs that come with an amazing concept, and they come to Andrew and they say, hey, look, I've got an investor purely just for the money. We've already agreed. I own the IP. They're putting in the money. They get a piece of it, but ultimately I'm the IP owner. That's okay. There's no rules. The only rule is write it down. That's the only rule.
Right. Because if you don't write it down, when you think about the investor argument or the partner argument, it does kind of make sense, right? This is what the investors will say. You either told us or it was implied we were getting on the ground floor of something that would grow. We took the biggest risk by getting involved before this was a thing. It's a thing now. You have much more higher likelihood of success at opening and maintaining a second one off of the success of the first one. So why wouldn't that investor that took the biggest risk get some kind of benefit in that growth? You never said we weren't involved, right? Why would we assume we weren't involved if you never said it? And there are different legal doctrines, common law doctrines that kind of support this overall argument by the investors in the absence of very clear rules about who owns what. We've seen so many lawsuits over this. Most of them settle, but it involves tons of money. So getting ahead of this not only preserves your relationship with investors, right, by avoiding this uncomfortable conversation and this disagreement down the road, but it can really just crystallize your vision for the future and for growth as well, and help make sure everybody's aligned from the get-go.
This is why the partnership agreements are so important. It's basically like a prenup, right? Like if something happens, you've already decided what happens to the IP assets. I mean, just recently we were dealing with a situation where a restaurant was closing down, and there were 7 different partners, and one of the partners wanted to take the IP and the branding and run with it, and the other investors were like, wait, absolutely not. This is, although the restaurant's closing, we still want a piece of it. And because the operating agreement was silent, the default is that the company owns it, meaning that all the investors and all of the members are also owners. So it's really important. You have to remember, if it's not written otherwise, the default is that the company owns the IP and everybody splits it.
Right. And look, in a perfect world, right, if you're, a founder of a restaurant, a bar, any kind of hospitality concept, ideally you'll reserve the brand ownership for yourself, right? And it looks something like this. Let's say Hamutal and I are starting a bar. We need some investors. We're telling those investors, Hamutal and I own the brand. You're investing in this location only. If we want to open a second one, Hamutal and I, we can do that, and you're not necessarily involved. That is possible to do, right? It's a harder pitch, though, for your investors. Ideally, we're doing it because we're reserving, all of those rights for us. But you're basically telling investors there's limited upside. You're investing in a lease. You're investing in a brick and mortar location. You're only investing in one, right? Imagine investing in Chipotle, but being told you're only getting profits from the first location. Chipotle becomes this big thing, and all your friends and family say, wait a minute, aren't you an investor in Chipotle? Shouldn't you be like a multimillionaire by now? And you say, well, actually, no, because I didn't invest in the brand. So nope, I got duped. No investor wants to do that. So it's tricky. We've seen these kinds of deals go through. Generally, the more successful you are as a restaurateur or as a hospitality owner, the higher likelihood you'll have of reserving the brand for yourself. If you can show, look, everything I touch turns to gold, maybe you can convince an investor you're not getting in at the brand level, you're just investing in this one location, and that's enough. If this is your first operation, you're going to have a harder time convincing investors to do that. Scalability is the name of the game these days in hospitality. I don't have to remind anybody on this webinar how hard it is out there, how thin the margins are, how tricky it is to make a profit. Investors know this too, right? So you're already at a disadvantage when you're pitching investors in this industry because the failure rate's so high. Investors want to say, let's reduce this risk by diversifying your portfolio. What does that mean? They want to invest in a collection of things. They don't want their investment to go to zero if one location closes. They want to get in on the ground floor of a brand that could explode so that they could, there's unlimited upside. That's generally what investors want. So when we say set proper expectations, understand that depending on where you are in your kind of career and how successful you've been, you may have differing degrees of success reserving the brand for yourself versus for investors. Either way, though, it's really important to have this conversation early and understand what you're selling. The good news about sharing ownership of your brand with investors, it makes the pitch so much easier. You're going to have investors so much more excited about investing in you, and it's probably going to increase your valuation because you're telling them you're not necessarily just investing in one. This brand has upside. We might expand it. If you have plans to expand it, you can talk to your accountant. We're not, this is a little outside of our field, but chances are it's going to increase your valuation, which reserves a larger chunk of the company for you as founders who are going to grow and build and drive this brand forward. So all of this is to say there's no right or wrong way to structure IP. The only wrong way to do it is not to do it, right? And just make sure you have the conversations early on.
Yep.
A common compromise, and this is something we're seeing more often these days. If you're reserving the brand for yourself, one way to get investors on board with that is to say, look, you're not automatically getting interest in a second or third or fourth location, but you'll have first bite at the apple in a future location. Meaning if we need to raise money, if we're talking to investors and we need to raise money for a second location, we'll go back to our first investors and say, look, you took a chance on us. You took the biggest risk. Thanks for that. Out of respect and loyalty for what you did for us to get us off the ground, we'll come to you first if we want to open a second or a third or a fourth. If we need to raise money, we'll come to you first. We're not going to go to some stranger before we offer a deal to you. And if we go to a stranger and the deal terms change, we have to go back to you and the clock resets and we offer you those new terms. This is often called a right of first refusal or a right of first offer, as it's listed here in the slides. This is a very common compromise if you're reserving the brand for yourself, and it's a way to get investors comfortable with the idea that I don't like that there's a ceiling on my investment. I don't want to invest in just one. What if you become successful? You create basically a pay-to-play way to participate in future growth. Again, I'd say 75% of the deals we're structuring these days assume that the master company or the holding company, we'll get into this in a minute, owns the brand, meaning you're telling investors get in on the ground level of the brand and you're sharing that ownership. 25% of deals reserve it just for the founders. If you're in that 25%, good for you. You've negotiated well. And this is a way to help investors get on board with that. We can go on to the next one. This is a very simple visualization of what a larger kind of hospitality group corporate structure looks like. You'll see at the top, we have what's called a holding company or a parent company. This is basically your mothership. That's where you and your investors, if you have any, you and your partners will live. You own equity in that company, and that company in turn owns 100% of each of your stores. When you see in this visual, there's venture one, venture two, venture three, all of those stand for separate standalone stores. You'll create LLCs for all of these ventures, and all the profits will flow up to that holding company. This is a very efficient way to structure your business. It's an easy way to grow it, and it makes sure that, as Hamutal said, we're insulating liability at the store level while consolidating profits at that holdco level. You'll notice off to the side in dark blue, we have a box for an IP holdco. This will also be an LLC. Most of the time, it's 100% owned by the holdco, but it can have different ownership depending on how you're structuring it. And that stands for your brand ownership. So you see the brand ownership is off to the side. It's protected, right? There are no contracts there most of the time. There's no liabilities attaching directly to that. And the green arrows that you see in this visual stand for licenses, which is basically just giving free permission to each of your stores to use the brand while protecting it and keeping it in orbit away from the actual, nitty-gritty operations where, the risks and the potential lawsuits live.
And by the way, you could have different ownerships based on venture one, venture two, and venture three, right? You could have investor A in venture one, two, and three, and maybe investor B is like, you know what? I want to just stay with investor one, and then you've got a different compilation. So all of this really does help keep those ventures separate. And we're going to be going over some other monetization strategies as well. So if you want to get into CPGs, if you want to get into franchises, there's licensing deals. You could have different investors and different groups on the different ventures. And so making sure that you've got a mothership and making sure that you've got an IP holding company also really does keep everything insulated and organized.
Yeah. And before I turn things back over to Hamutal to get into some of the processes of the trademark application process, I did want to share some anecdotes that we've been hearing from clients, right? And some of these people are very, very successful restaurateurs that have been doing this for decades and decades. We talk to hospitality operators every day, and there is an overwhelming consensus. It's amazing because I've had this conversation 3 or 4 times this month with people who don't know each other. They haven't interacted. It's not like they all talked each other into this. They're just all arriving at the same conclusion separately, which is that in the current economic climate, they're really gravitating towards scalable concepts. If it works in New York City, great. Maybe you want to open a second and third in New York City, but maybe you're looking at secondary markets also. Maybe you want to look at Miami. Maybe you want to look at Texas. Maybe you want to look at Las Vegas. Maybe you want to look at LA. Successful hospitality operators are thinking nationally and in a lot of cases internationally to think about where can we take advantage of markets? How can we expand our footprint and take advantage of a brand? These are great things to be thinking about. Know that your competition is doing it. Know that the most lucrative hospitality groups out there are already doing it. And this is really where the margins are, right? And taking advantage of economies of scale, bulk discounts, leveraging your brand, leveraging your holding company. So setting things up the right way at the beginning, right? Before you're even thinking about, other cities or other countries to expand, it can save you so much time and money to take these relatively simple steps at the beginning and pave a way to do that. We're working with a lot of clients that are hoping to do this that did not do this step at the beginning. And I can tell you it takes so much longer and it's so much more expensive. And the only people who win in that scenario, frankly, are the lawyers, because we have so much cleanup work to do to get them back on track for what we want to do. And that's not work we really particularly enjoy doing because we'd much rather take the path of least resistance and have a linear path for you at the front end. So it's really interesting. And I think it's the fact that we're doing this webinar this year is a reflection of this trend that we're seeing in the industry, right? Where it really is all about economies of scale. We see people, chefs that are known for having some of the top restaurants in the world that aren't replicable, moving more towards scalable concepts. That's not to say they're opening, they're going with a Chipotle model, but they're going with higher end restaurants that are a little more scalable, that are easier to teach, that are easier to license, easier to franchise. Again, it's not saying that it's any worse of a restaurant, but it is probably more repackageable and scalable than maybe something they would have done 10 or 20 years ago.
Yeah, people want to get paid. Nothing wrong with that.
Yep, exactly. All right, Hamutal, floor is yours.
All right, so we're going to go into a little bit more of the nitty gritty of the trademark, just concepts for those of you that don't know it. For those of you that do, hopefully this is just a quick little refresher. So it's important to understand how you're using your trademark. You are not allowed to own a trademark indefinitely for every single use and concept in the world, right? So what the USPTO and what the international World Intellectual Property Organization does is break down, there's 45 different categories known as goods or classes, and that we need to identify in your trademark application, whether it's domestic or international, how are you using it? The most common that we see are in the hospitality industry, like I said, are restaurant and bar services, hotel services, catering, mobile food trucks, also online brick and mortar retail services, alcoholic beverages, non-alcoholic beverages, beer. So these are just some of the top categories. Super important to tailor your trademark application to exactly how you're using it, because if it's too broad, your application could get canceled. If it's too narrow, then potentially you can let a competitor kind of encroach on your brand. So we need to make sure to really craft that expertly. All right, let's talk about common law or unregistered trademarks. So there in the US, there's a concept called common law or unregistered trademarks. And these are rights, trademark rights that are attached to use in commerce. And they are limited to a certain geographic location. So let's pretend that Andrew and I open up the Ha Bar. I just thought of that, HA. And we're opening up in New York, and we decided we want to skimp on the trademark application. We still have common law trademarks in the word Ha Bar because we're using it in New York, but our rights are only limited to the state of New York. We can't prevent somebody else from using it. We can't transfer our rights. If we decide, hey, we're done operating Ha Bar, but we want to sell it to somebody else, it doesn't work that way. We can't do that. And again, once we cease operations, let's say we decide it's not for us, we're going to stick to our legal careers. We lose all rights in the word Ha Bar because we didn't register it. So it's a good stopgap for those people that are operating now and you're kind of freaking out that you don't have a registered trademark. You still have some kind of protection, but registration is always the golden standard. There's, as Andrew was saying, we're seeing a lot of clients expanding internationally, and you of course can own an international trademark. There's different options, which you can either file a trademark application in every specific country that you're planning on operating, or you can file a single trademark application. It's called through what's called WIPO, which is the World Intellectual Property Organization. And that allows you to file a single application and designate certain countries. You do need a local representative to sit in those countries, and we obviously have relationships with all the different countries that we work with, so it's not a problem. The issue is that oftentimes people go a little crazy, and not only can that be expensive, but if you end up not expanding in those countries, you end up losing the trademark. So things to keep in mind. Oftentimes we'll work with clients that are expanding into their first country, let's say. And for example, thanks to Brexit, this is something that people forget about. The UK is completely separate from the EU. So oftentimes people are like, oh, I want to file an EU application. And I'm always making sure to double check. Does that mean specifically the UK, or does that mean the EU? So we're seeing a lot of those tandem applications, but also Japan has been really hot lately. Australia has been really hot lately. So it's good to think about a 3-year, I always say a 3-year horizon. If you're thinking about potentially expanding in the next 3 years, let's do a trademark search internationally. Let's see what is out there, because like we talked about, all the corporate structuring and obviously the branding is the easiest to do up front, right? There's nothing more devastating than having to rebrand after you've launched. And look, we've seen a lot of companies that come over from Canada and they've run successful companies in Canada. They never imagined that they would expand into the US. And now, there's a competing brand in the US, and so they have to rebrand. There's ways to do it, but if you're able to start clean and fresh from the beginning and do a search, we could do international searches all the time and say, okay, right now this is clear in the first 5, geographic targets that we're planning on. Let's go with this word mark. It's always the best. All right, so I'm going to go through a little bit, some tips about selecting a name to trademark. So of course, like I said, you can trademark a name, a cocktail, a mocktail, a menu item, a restaurant. Usually, again, it cannot be a name, like a first name or a last name. Obviously, you've got the Jose Andreses of the world where they've used their name in commerce for so long that there's a famous kind of designation attached to them where a consumer can identify, can separate a brand separate from that person. But for, the entrepreneur that's starting out, usually it's not common. Same thing is you want to make sure that you're not describing, your name does not describe your goods or services, or are a primary feature, right? So like my example here, you can't register guac and chips for your Mexican restaurant. It's never going to get through. It's considered descriptive. It's considered to be a primary feature. We've had issues with several of our clients that have great names, but they're very descriptive. So again, if you're starting out fresh, clean slate, keep this in the back of your mind. All right, the next is we want to make sure once you've selected a name, another thing to consider is avoid what's called a confusingly similar objection from the USPTO, the United States Patent and Trademark Office. So what does that mean? The USPTO wants to make sure they are there to protect the consumer. Keep that in mind. And they assume that the consumer is uneducated and gullible, frankly. And so they want to make sure that you don't have two marks that are registered that are considered confusingly similar for same or similar goods. So the analysis is fairly lengthy, but when it comes down to the gist of it, the marks don't need to be identical, but do they sound alike? Like for example, Vizzy and Brizzy, these were deemed to be confusingly similar. Do they look alike? Exceed or exceed, right? They're spelled differently, but they still look similar. Do they have similar goods or services, right? We've been getting this a lot, and this is especially in the hospitality industry. Restaurant services now we're seeing are becoming a more broad kind of designation for what is considered confusingly similar. So for example, I mean, these are things that are happening all the time right now where we've been dinged on saying that a restaurant name is confusingly similar to a similar restaurant name that's a meat distributor, right? And they're claiming, well, the restaurant has some kind of, barbecue restaurants. And this also has to do with the fact that, as Andrew was saying, a lot of restaurants and a lot of brands are expanding, right? Scalability. You're seeing a lot of different restaurants and hospitality brands kind of spiral off from an original brick and mortar store. And so the USPTO is really trying to protect the consumer and understanding that the consumer can differentiate between two specific brands that are different.
Right. Hamutal, if I could just add something here, I think this is a really important thing to remember, because technically anybody, right, could do a simple word search on the USPTO website. I'm sure some people in this call have done it. I've done it, where, I'm not a trademark lawyer, but I can do a simple word search to say, let's say, taking the ha bar from Hamutal and I, we want to see if there's a ha bar somewhere out there. I type ha bar and search on the USPTO. It lets you do that. And it'll say whether there are any, marks out there that are almost identical, right, to that. Just because I see 0 results under Hotbar doesn't mean I'm good to go. Doesn't mean I'm guaranteed to secure a trademark. A process that can take a really long time, by the way, like 8 to 12 months it can take the USPTO to review an application. It's kind of wild. It's important to remember that, because I think I talk to a lot of clients that do their own homework, and good for them, right? To the extent they can do something themselves and not use lawyers, I'm all for it, right? I don't want to take money from clients that can do something themselves. But a lot of clients misunderstand how broad and kind of artistic this search really is. It's not an exact word. It's not saying, oh, I'll add a letter and now I'm safe. Because the PTO may still come back and say, no, because this looks very similar to this other one, or this feels very similar to this other one, or this is similar. And I think in the visual in this slide, you see the Vizzy versus Brizzy. I don't know that would come up if you did a word search.
Oh, definitely not.
Probably wouldn't. But the USPTO may come back after that excruciatingly long 8 to 12 month review period and say, sorry, we're not protecting you because it's confusingly similar to this. What's likely to happen in that 8 to 12 months? You're spending all your investor money. You got the signage, you got the brand, you got the website, you got everything else. And now all of a sudden you have to rebrand, and that's really expensive. You got to go back to your investors with your tail between your legs and say, more money, please. Nobody wants to do that. Yeah. So it's important to understand what really goes into this and how intricate what seemingly is a very simple search truly is. I'm always encouraging clients to do a knockout search with Hamutal before they invest too much in the brand, because there's a lot more that goes into that than you think. And the USPTO is actually a lot more thorough than I think a lot of people give it credit for.
Oh yeah, absolutely. And look, it's a great place to start because of course, if you see an identical hit, move on, right? Like it's not, but we want to make sure also like there's even intricacies in the results as well. Like if you're trying to open up a restaurant and maybe you see a baby clothing line with the same name, you're probably okay. Again, caveat probably, but definitely skipping on the search is not advised. All right. Again, we want to avoid, you want to make sure that you're avoiding a geographically deceptive objection as well. So I don't know how many of you know, but Panera used to be called the St. Louis Bread Company. And guess what? Before they expanded and before they, I think they got through their Series C funding, they were forced to rebrand by their investors because there was absolutely no protection in the word St. Louis Bread Company. Why? Because they were located in St. Louis, and bread company bread was one of the things that they were serving. And so by doing that, by rebranding to Panera Bread, look, you can kind of see they even kept like similar fonts and things like that, but it was able to really give them a name that they could protect and more importantly monetize. So it's really important to keep things in mind. You're never allowed to own a country, a state, a city, or a town. It's just not possible, right? So if you're thinking about calling yourself, the Paris Club, probably not going to work out for you. So, things to just keep in mind when you're thinking about a name. And again, these are things that unfortunately your branding professionals probably are not going to reach out to you. They're probably not going to do these searches for you while you're selecting the name. So it's always good to keep this in the back of your mind and run it by a trademark lawyer. Again, the one of the other concerns to avoid when picking a name is a merely descriptive. Again, we're talking about you can't own the name Apple in connection to apple orchards, right? But you can of course own the name Apple in connection to electronics, right? It's not descriptive. You can't own the word bakery for baked goods. Even something like cold and creamy for ice cream has been deemed to be merely descriptive of what you're selling. So these are all things that a lot of people don't really think about. And as Andrew was saying, there's a lot more that goes into kind of like the legal parameters of naming a name and picking a name to trademark.
And a lot of this makes sense, right? Imagine you want to, put on your menu, hey, this ice cream is cold and creamy, and then you get a letter saying, sorry, this competing ice cream shop owns those adjectives, and you can't use those adjectives anymore, right? Like imagine the strain that would put on the English language. So as Hamutal said earlier, and I think it's a great thing to remember, the USPTO doesn't exist to protect companies, right? It exists to protect the consumers. And it exists to make sure that companies don't overreach and monopolize the English language or overreach in a way that's going to confuse or mislead consumers, right? So make sure that if you go to the store and you want to buy Apple headphones, some cheap knockoff can't just mislead you and say this is Apple or say this is something very similar and have packaging that's going to deceive you. And say, oh, I spent this and I didn't really look at it that carefully. And it turns out this isn't Apple and these don't work. That's what the USPTO is there to do. So when you're thinking about your name, put yourself in that seat. Don't think about what's going to sell the best. Think about what possible reasons would a consumer protection agency have to deny this application. Because I think that's something that people forget. The USPTO doesn't exist for the protection of companies. It exists for the protection of consumers. And that's kind of the lens through which we as lawyers look at these names.
Yeah. And I don't mean to shatter dreams, but I do it every day. So many people come to me with these like dreams of names, and it's like, of course it could be a wonderful name, but my goal is to have your best interests. And I'm able to kind of put an arm's length distance between me and your creativity. And it's important. It's really important to have somebody that knows the rules kind of safeguard to make sure that you're not going down the wrong path, investing all this money only to have a name that you can't monetize or protect. All right. So as Andrew was talking about, this is a very it's a lengthy timeline. So essentially, once you decide on a name, we file an application. Right now, it's taking 8.5 months for your file to be assigned to a trademark examiner at the USPTO. So that means you hear nothing, zilch, nada, for 8.5 months, which is why it's all the more important to do your search up front and to feel confident in the name, because you're going to want to be investing in marketing. You're going to be wanting to pitch investors during this 8.5 months, right? You're not like, oftentimes people are doing a lot of these things simultaneously, right? You're raising money while you're applying for your trademark. You're signing a lease, you're doing your build out, all of these things, and you want it to be able to work out at the same time. So really important to do the search at the appropriate time. At the 8.5 month mark, you're going to get the USPTO examiner is going to review your application, and they're going to issue any of the objections that we just talked about. Is it geographically descriptive, deceptive? Is it merely descriptive? Is it confusingly similar? Are there other reasons why that the trademark office has an issue? Once you go through that scrutiny, then there's a 30-day publication or opposition period where the public is allowed to submit objections as to why your trademark should not be registered. Oftentimes, this is a rubber stamp process, and existing trademark owners are not informed of the process or that it's even published. However, if there's a mark that you are policing, which we'll talk about in a second, and you're watching because you do believe that it's similar, this is an opportunity for you to stop the process and to voice your concerns and potentially cancel, stop the registration of a trademark, which is very important on the prosecution level. So different things, and your trademark attorney will be monitoring these things and will be able to help you out in these instances. Once you get through the opposition period, your registration certificate will be issued within 2 to 3 months, and you're good to go. People often ask me, how long is a trademark good for? It's good for indefinitely as long as you're using it. So you have to submit certain maintenance documents, which basically shows the trademark office that you're using the mark. The first is due between the 5th and the 6th years after registration. So a little bit of the timeline. All right, so now kind of the last little element that we want to talk about, and you've heard Andrew and I say this over and over and over again: scalability. What are your competitors doing? What are the big brands out there doing? And we're going to highlight 3 such monetization and growth strategies that we're seeing a lot. So the first are consumer packaged goods, CPGs, right? A lot of this, and we saw a huge burst of this after the pandemic. We saw a lot of hospitality brands turning into monetizing their key brands, right? We've got Milk Bar, we've got Bubby's, we've got Carbone. All of these are New York focused restaurants, and yet here they are, they're on the shelves making money. It allows these hospitality companies to derive revenue outside of the restaurant's walls. We know that running a restaurant has thin margins. So this is a way to really just put on passive income, right? You've already got your recipe. Now go talk to a co-packer. Now talk about packaging and get that product on the shelf.
What's so appealing about CPG for a lot of hospitality owners is there are a lot of people who will experience your brand for the first time in a supermarket. Right? They'll try this and be like, oh my gosh, there's a restaurant attached to this. Let me try the restaurant now. Right. And now all of a sudden you have a higher demand for your brick and mortar as a result of expanding your audience. And obviously the opposite is also true, right? If you have some regulars that love your sauce and love your product, they're much more likely to go there. I'm fortunate enough, I won't use names, but there's a Mediterranean restaurant near my apartment that has a product on a shelf in a retail store, and I always get that product. And I have a 7-month-old daughter, and we're trying to introduce her to solid foods, and that's the only food that she will eat is specifically hummus from this store. So it's not like I can take my 7-month-old daughter to this restaurant, but I do now am able to support that brand by going to a store and buying this hummus for my very spoiled 7-month-old daughter who will only eat, a Michelin bib quality hummus.
Yeah.
So it's an example of, monetizing, like we said, this brand. What does that mean? It's such an easy thing to say. It's harder to illustrate how it happens. This isn't for everybody. There are some hospitality owners out there that says, no, I'm never going into stores. It's too special. I'm never doing that. There are a lot of hospitality owners that are saying, look, if we're going to be scalable, I want as many eyes on this brand as possible.
Yep.
And it's not just for the consumers, it's for developers. It's for, and we'll get into this in the next slide, it's for other partners to recognize we're serious about scaling, we're serious about growth. The bigger your footprint gets, the more opportunities that tend to come.
Yep.
Unfortunately, in the American, capitalistic society, there are benefits to being large, right? The bigger you get, the more opportunities come. It's very hard to succeed in this industry with a very limited footprint and without any aspirations for growth whatsoever, whether it's opening new locations, franchising, CPG, license, whatever it is you're doing. It's just important to know what the options are and to think about what might be the best fit for your brand.
Exactly. And I think in this instance, there's oftentimes we see again, as you're seeing with these examples, you have a hit sauce, right? You have a hit product. That's when you should start thinking, okay, is this something that I can put in on shelves? And it really is a great way to just, bring in passive income. All right. So on to the next of the monetization strategies. So the next thing you can talk about is licensing your hospitality brand. Andrew, you want to jump in?
Yeah, sure. So, what we're seeing a lot, especially post-pandemic, is very successful operators getting approached by developers to say, "Look, I love this restaurant. Could you bring it to me? I'll build it out for you, right? I will build out a perfect space for your concept. I just want your restaurant in my hotel. I want your restaurant in my condo. I want your restaurant in my mixed-use building. Bring it here, or bring me something very similar to it, and I'll pay for all of it." It's a very easy way, and this is, a lot of you on the call know this already, but F&B management, F&B consulting, F&B licensing deals allows you to basically take a proven formula and repackage it somewhere else, take responsibility for the training, for in some cases the management. There are a lot of ways to structure these potential deals, all of which are very low risk for the brand owner compared to signing a lease and adding a personal guarantee and potentially exposing your assets, raising all the money yourself, doing all that for yourself. Once you get a certain level of notoriety in the industry, you're going to have people presenting you with opportunities, believe me, you didn't even think were out there. Once you reach a certain kind of scale, you'll have opportunities and people coming to you with the right connections, the right broker, et cetera, saying, please come to me. I'll build it out. I just want you, your talent, your infrastructure, your team
And your
behind
following and your brand,
it,
right?
following in your brand.
It's all of it. That's why they're coming to you because you have built a following, right?
Exactly.
I was just in Vegas for the Bar and Restaurant Expo, and I think Vegas is like the licensing
Mhm.
city of the world. There is not a single restaurant that you can't find in Vegas. It is, and it's such an amazing opportunity because, right, these casinos they've got food courts with full of different brands, right? And they want these famous brands to come so they can attract consumers, right? They want people to be like, I want to go to the Venetian food court because they've got Bobby's, burgers here, and they've got, all these different brands here. So it's really, really important. And again, it all stems from you've invested in your brand, you've protected it, and now it's time to monetize it.
And the reason we're talking about this, and by the way, we have an entire series on kind of management licensing agreements. So if you have more questions about this, stay tuned in our series. We're going to be talking about these, and we have recordings of past past webinars we've done on this topic. So if this is a topic that's interesting to you, definitely reach out to us. We have materials for you. But the reason we're roping this into the trademark conversation is you're not going to get anywhere. You're not likely to make traction with these larger developers unless you can prove to them, hey, this brand is protected. Right?
Mm-hmm.
No one wants to spend hundreds and hundreds of thousands of dollars building out a restaurant for you if there's a risk that on day one of opening you're going to get slapped with a cease and desist and now you have to rebrand because that defeats the entire benefit of that deal from the real estate developer.
Yep.
Right? Because
Yeah.
they're banking on the name recognition. That's the whole reason they're paying that money is they want the prestige, they want the name recognition, they want the brand, and to Hamutal's point, the following that derives from that trademark. So,
Yep.
again, this is another example of why it's so lucrative to trademark your brand and why it's so important to do it early, because we definitely had clients have enough success to merit those kind of opportunities, but not the infrastructure to actually allow those deals to move forward. because there's always a diligence period following this initial inquiry to say, okay, well, send me your trademark, send me your org chart, send me your corporate structure. If you're ahead of the game, you're going to be like, easy, here it is, copy and paste. But if you're behind the game, then it's like, actually, could you give me 8 to 12 months to trademark this? They're going to lose interest during that period. So getting ahead of it and being ready to pounce on these opportunities, I think is very important. We've seen a lot of clients lose out on some really, heartbreaking opportunities as a result of just not having their ducks in a row quite yet.
Yeah, exactly. And I think the unique element of this, of a license deal, is that you as the brand owner still retain brand ownership. You're just entering into a monetization deal, basically, where you get paid for your brand.
Yep.
So, all right, we can move on. A couple key deal points that Andrew will kind of run through.
Yeah, I know we're coming up on time. I don't want to spend too long on this particular point, but when you're entering into a deal, whether it's a management, a consulting, a license deal, usually it comes with some element of a license of your trademark. You're going to get a fee for that, right? You have to explain, is this an exclusive license? Are you saying, hey, Hilton, you're my only brand partner on this deal or not? What does the license entail? Is this an exclusivity arrangement? What amount are you getting up front? What amount are you getting over time? Again, we cover this in other webinars, so I don't want to spend too much time on this. In the interest of time, I'm breezing through a little bit. The other thing I want to disclaim is if you're thinking about licensing your brand in a passive way, where you're not actively managing it and you're just giving somebody else permission to use it, you'll definitely want to talk to a franchise lawyer, because we'll talk about this in the next slide. It's very easy for what is called on paper an intellectual property license to accidentally qualify as a franchise. So
especially, in the hospitality.
As a franchise, it might accidentally qualify. Every state has a slightly different rule set on what qualifies as a franchise, and New York classically is very strict on this. It's very hard to actually structure a license deal without it accidentally falling into franchise. So make sure you're talking to a franchise lawyer when you're doing license deals that involve management by other people. But licensing deals, pick your top favorite, large hospitality groups. I guarantee you they've got a bunch of these in orbit. A very low risk way to kind of increase your profit margins, expand your portfolio, and get your name out there. Right? You just have to pick the right partner and make sure, to the extent you're outsourcing the management as well, there are some quality controls on that. As I said in this frame, it's very important to make sure you're not expanding in a way that's going to dilute your brand or harm it or tarnish your reputation, because that's ultimately what you're trading on.
Exactly. Quality control here and license deals is probably the key. You want to make sure that you're not something that's called a naked license, is where you're just letting somebody run off with your name and you're not really enforcing the standards behind the brand, which again comes back to the USPTO and the consumer's protection. All right. And then the last concept is franchising your hospitality brand. Of course, this is another really great expansion model that basically allows another individual or an entity the right to operate your business using the franchisor's brand or business, and essentially run a business. Obviously, this is huge when it comes to fast food restaurants. Coyote Ugly, I don't know if you guys know, is a franchise. So there are this is a lot more hands-on than a license deal is. You're setting out brand standard guides. You're really controlling how the franchisee operates their business, because they are operating a franchise, essentially a copy of your store. So it needs to be identical, the same POS system, the same vendors, obviously the same recipes, marketing, training, standardization. It really is an off-the-shelf kind of business. And it's, a franchisor is much more involved than a licensor is.
Yes. Keep in mind, the Federal Trade Commission regulates this, right? So we have a lot of clients that kind of do an off-the-shelf, they chat GPT their way into a franchise. Don't do that. This is a very specific set of rules and guidelines you have to follow. It's doable, but it is a system. It's something where you have to create a system. You have to really spend time getting the paperwork right on the front end, with the idea that if you spend that time, then you can basically copy and paste the next 50 times as you find franchisees over time. Just know that if you're going this route of trying to get other people to kind of use your brand, talking to a franchise lawyer at the beginning is a great thing to do, because it can help chart out a roadmap and avoid the need to backtrack later.
Yeah.
Yeah.
All right. So we'll run through again. You want to make sure, so I can't stress this enough. We've talked about policing and protecting your brand. Owning your trademark is a right. Okay. It's your obligation to police your trademark. That's why people get cease and desist letters, right? That's why you sue in court and you protect it, because nobody else is going to protect your brand unless you do. So you have your trademark, you've worked so hard to get it, to move through the registration process. Now you have to be vigilant. You see somebody that's operating in a similar capacity, we send them a cease and desist, and if it doesn't work, then we sue them. And that's kind of how it works. When you have a registered trademark, you have a lot of advantages in court. One of the things that a lot of people don't understand is that if you are found, if a company is found to have been infringing on your trademark, you're able to get what's called a disgorgement of profits, which means every dollar that the infringer has made under your brand comes back to you. You also get attorney's fees, and you can get a 3x multiplier if it's found that the infringement is willful. So oftentimes that's why cease and desist letters are sent. People are like, oh, why do you do this? It's not just, to be cute. It's to be able to show and to lay a path and groundwork for suing for treble damages in court.
Right. And it's unfortunately rewards the aggressive operators, right? Because if you fail to police this,
Yep.
that could undermine the protection. And I think, this is something I didn't understand before I went to law school. I don't think it's particularly intuitive, right? I certainly don't blame people for not realizing that this isn't a question of, are you going after money? Money is often a byproduct, right? It's are you protecting your brand and making sure that your trademark gets the respect and exclusivity that it deserves, because you don't want somebody else operating with your, unless you have a separate coexistence agreement, which is another thing. If you know something's out there and don't do anything, they could actually develop local protection over that brand. So you could change your mind and say, actually, you know what? 5 years later, I don't want to do this. It's harder, actually. If you let something sit for a long time,
Oh, yeah.
it's harder to go after them.
Well,
So,
and also, yeah, again, and like then you've got the challenges of like generic brands, right? Like STK, right? I mean, good for them. They got the trademark, but good luck enforcing it, right? It is so generic. They have a really hard time. Their lawyers have a hard time cut out for themselves. So just things to consider. Kleenex, right? Used to be a brand name until it was used so much. They didn't police it. It became too much in the fair use. And now Kleenex is essentially a generic word for tissue. So, things to consider. All right, we made it through. Thank you so much. You guys have been so diligent. I know we dropped a lot of information on you. And we kind of ran a little bit over. If you've got any questions, we're happy to stay on, answer some questions. If not, feel free to email us. We're
yeah.
around. We're happy to, talk to you guys about your individual questions, concerns, and
Absolutely. Feel free to type questions in the chat if you have them. If you want to have a separate conversation, feel free to email either one of us and we'll get back to you. But thank you all for taking time on a Monday to kind of talk about this with us. It's always a pleasure to have these conversations and try to get ahead of some of the regulatory issues. Believe it or not, we as lawyers love to do things right the first time. We don't like fixing things in the back end if we can avoid it. As much as it's more fees for us, that's not really the game that we're about here at Hamutal Lieberman. We want to do things right the first time and take the path of least resistance. So we appreciate everybody really investing their time into this, and hopefully it was helpful. Hopefully it was even interesting.
Yeah, and look, this Hellbrown Levy web series is here to empower you and our clients with as much information as possible. So do not hesitate. Ask questions of everyone, of your design professionals, of your brand concept, of everyone. So hopefully we've empowered you with some useful information today, and it's been a pleasure. Thanks for coming.
Let us know if you have other people who are interested in attending that were not able to. Just shoot us a note, because we can send you or your network a recording of this completely free. So let us know how we can help. Otherwise, thanks again for joining. We hope you all have a wonderful day.